Ralph Sarmiento, the Dean of the College of Law at the University of St. La Salle. Good morning to you, sir.
Good morning po.
All right. Now, do you believe that there could be possible questions with the legality of Duterte's arrest? Duterte's team is pointing out Article 59, Paragraph 2 of the International Criminal Court, which states that he has to first be surrendered to a judicial authority of the custodial state.
Well, actually, I've already written an opinion about that and posted it on my Facebook page. And my opinion was that the Article 59 of the Rome Statute is no longer applicable in this particular case, precisely because the Philippines has already withdrawn our participation or membership in the International Criminal Court. Now, Article 59 specifically refers to the state party, and while Paragraph 2 refers to the custodial state, that custodial state must refer to a state party, which is a custodial state insofar as the conduct of the arrest is concerned.
Okay, so what you're saying is Article 59 does not apply to Duterte's arrest because we've withdrawn from the ICC, correct?
Well, technically, yes, but I do understand and I do expect that this particular issue will also be raised by the camp of former President Duterte before the International Criminal Court. But we must understand that the intention and purpose behind Article 59 is just to ensure that number one, the identity of the victim, who is the identity of the accused who is being served or is the subject of the warrant of arrest, and also for the purpose of ensuring that his rights are duly observed and respected. And as long as there's an assurance about those two things, and that the person who is intended as the subject of the warrant is the person who is actually arrested and is turned over to the jurisdiction of the International Criminal Court. Normally, in previous cases before the International Criminal Court, they usually assume jurisdiction despite those allegations of irregularities attending the arrest.
Okay, but then, Dean, what is the balance here? The Philippines is a sovereign country. The judicial system in the Philippines is working. There are petitions before the Supreme Court. The Philippines is no longer an ICC member. You just said Article 59 does not fall under the Philippines because we are not a member state. So how then, what are the ways under the law can you take someone under custody if you are not a member?
Well, we must understand that
without undermining the sovereignty of the Philippines.
Well, number one, there were previous cases. For example, I can cite the case of Adolf Eichmann when he was abducted in Argentina by the Mossad or the Israeli secret agents. We also have the case of prosecutor versus Dragan Nikolic when he was. When he was also allegedly abducted in Bosnia and then surrendered to the International Criminal Tribunal for the former Yugoslavia. They both cases raised the question of sovereignty, and in the Eichmann case, the District Court of Israel mentioned that the defense of sovereignty or sovereignty is a personal defense to the state, meaning to say, if ever or even assuming that there is an allegation of violation of Argentine sovereignty attending the arrest of Adolf Eichmann, it is only Argentina that can raise that particular question. And also insofar as the case of Dragan Nikolic in Bosnia is concerned, only the state can also raise that question. So if there's a question about the violation of sovereignty, only the Philippine government can actually raise that question, and I don't think the former President Duterte will be in a position to invoke the sovereignty of the Philippines because that's a personal defense to the state itself.
Okay, very good point there. So technically speaking, it's only the Philippine government, President Marcos Jr., who can raise that argument if he wanted to.
Yes.
But then the question is, why would he when the government itself actually prepared the plane to ship off the former president?
Precisely. Yep.
Now, how do you strike the balance between the petitions before the Supreme Court. The Supreme Court not acting on those petitions that is meant to protect the rights of a Filipino citizen versus an international court taking jurisdiction of a Filipino citizen.
Well, I'm sure the Supreme Court retains jurisdiction over questions involving allegations of possible violations of fundamental human rights insofar as Philippine law is concerned. But insofar as, in the context of the validity of the warrant of arrest, insofar as international law is concerned, particularly the application of the Rome Statute and the ICC rules on evidence, those are within the jurisdiction of the International Criminal Court. So it's not a question of which will prevail, whether it's domestic law or international law. I would say that there is supposed to be no conflict because both laws actually operate on different spheres of application. So international criminal law, insofar as the questions involving application of the Rome Statute, they are within the jurisdiction of the International Criminal Court. Now, insofar as allegations involving allegations or claims of violations of fundamental rights of former President Duterte under the Philippine Constitution, they remain to be under the jurisdiction of the Philippine Supreme Court. However, you must also understand that in cases like this, there's a possibility that the Supreme Court might consider these things as a political question and not for strictly legal or technical reasons, but for prudential considerations. I would say for prudential considerations because we must understand that the Philippine government, the executive branch, is already making its own actions or position in this particular matter. And if the Philippine Supreme Court will take a different position, then we might lose our face before the international community because we will be a country whereby we have the two main branches in the government would be contradicting each other.
Okay,
so
but what if the Supreme Court acts on the petition and just hypothetically asks that Duterte's body be produced back to the Philippines? Because that's one of the petitions in effect, no? I'm rephrasing.
Yes, technically the Supreme Court retains the power, the authority to issue a writ of habeas corpus. But a writ of habeas corpus only requires the person supposedly holding the person in detention or the subject in detention either to produce the body, or if the body cannot be produced, then to justify the reason or to provide for the reason for the detention. So if the body can no longer be produced because we all know that he's already in the custody of the International Criminal Court, then all they have to do is to explain or to justify the reason for the detention, and that would satisfy the writ of habeas corpus.
Okay, but let's just say that the Supreme Court asks that Duterte is brought back to the Philippines. This is purely hypothetical. Is the ICC mandated to follow the Philippine Supreme Court?
Unfortunately, no, because number one, our Supreme Court, although we call it Supreme, has limited jurisdiction, means its jurisdiction is only limited within the confines of the Philippine territory and jurisdiction. So beyond our territory and beyond our jurisdiction as a state, then the Supreme Court decisions, orders, or directives will no longer have any binding effect outside the Philippines, and much less over the International Criminal Court, over which the Philippines, as a domestic court, has no jurisdiction over.
Now, should the Philippine government have surrendered a Filipino citizen? This was the argument of Vice President Sara Duterte, saying that the Philippine government surrendered a Filipino citizen and a former Philippine president at that. I've been reading feedback that no other country would do this.
Well, number one, we must define what we mean by surrender, because technically, I'm sure Malacanang will not agree with the use of the term surrender. I've read some statements, and I've also received some messages. They are protesting the use of the word surrender, because I think the position that's being taken by the Philippine government is that they did not surrender, but they were just complying with an obligation with the Interpol, considering that there is the there is a request, there is the enforcement to pay warrant, and that indeed there is a warrant issued by the International Criminal Court, which which issued the warrant pursuant.
But whether you surrender or comply in this context is the same.
Technically, in layman's point of view, but in the legal point of view, it may have a technical difference. Yeah.
But then, you had the president at one point when the relationship was better, when he said the Philippines will not cooperate with the ICC. The Philippines will not recognize the ICC.
Well, I'm also of the opinion that technically, whether or not the Philippine, the president will comply with the said or enforce the said warrant, will still be within his part of his discretion in the conduct of foreign relations. Although, of course, if you violate our obligations under international law, it will violate, the principle of pacta sunt servanda, because international obligations must be complied with by member states in good faith. So it may also have some repercussions insofar as our relations with other states under, before the international legal community.
But do you believe that? I mean, I'm just making, this is for discussion purposes here. The United States, which is the most powerful country in the world, is not a member of the ICC. Why would it affect them? Why would it affect us? You have very powerful countries who aren't members of the ICC.
Technically, the United States is not a member, but if a U.S. citizen is charged with a crime, that is a crime that is falling within the jurisdiction of the International Criminal Court and is allegedly committed within the territory by a member state, then it may still fall within the jurisdiction of the International Criminal Court. And that is why President Trump is taking a very strong stand against any state, or even threatening to sanction any state or to stop the giving of economic aid to any state which will assist the International Criminal Court in this regard.
All right, no, I'm asking you because you just said by not cooperating, it would affect our international relations. But why would there be that standard when you have powerful countries who are not members of the ICC? It doesn't affect their international relations.
Yes, but we must understand that the United States is not the only country in the world, and there are so many member states, particularly in the members of the International Criminal Court, where we have
mostly the EU
economic relations, particularly the European countries, and we still maintain relations with them, and so it might have repercussions in our relations insofar as these states are concerned, because many of the states, particularly the European states, are so concerned about preventing impunity, and that is why they are very strict about complying with ensuring impunity, with ensuring prosecution and punishment of international crimes, which are supposed to be the concern of all states in the world.
Okay, now do you believe this could be an argument that the Duterte team will make at the ICC? In July 2023, there was a petition before the appeals court. And I'm sure you're familiar with this. There was an affirmative vote of 3-2 when it came to the jurisdiction issue. But 2 ICC judges actually argued that the Duterte trial is out of their jurisdiction. So I'll quote this. In an earlier decision, ICC judges Bricambot, the chief judge, and Lord Kispanzi argued that the ICC does not have jurisdiction over the Philippine situation, the case regarding the war on drugs pending before the ICC, because the Philippines is no longer a state party under the Rome Statute. In the jurisdictional decision, the vote was close, 3 in favor and 2 against, including the chief judge. So why am I bringing this up? No doubt they will bring this up and use this before the ICC, that there's even a close issue with the jurisdiction controversy. What is your take on this?
Well, technically, number one, whether that can still be raised by the camp of former President Duterte, yes, it can still be raised because we must putting it in context. In 2021, it was the Philippine government which asked for the deferral of the investigation and also questioned the raised questions regarding admissibility, complementarity, and jurisdiction of the court. And so, technically, the accused former President Duterte never had the opportunity to raise that issue because it's only now that the International Criminal Court acquired jurisdiction over his person. So definitely this the accused can now directly again raise this particular question, not only with respect to jurisdiction but also with respect to admissibility. And then well, this is a very contentious issue, and it may require technical interpretation, particularly Article 59 and Article 127 of the Rome Statute.
Okay,
Now,
can you explain Article 127, sir?
Well, in Article 127, there are upon the withdrawal of a state. It says that it shall be without prejudice to the continuation or the assumption of jurisdiction of the International Criminal Court. But the contentious issue there is that the investigations or the charges, the formal charges were actually filed after the withdrawal of the Philippines has already become effective. But however, the other contentious, the other point there is that the criminal or the preliminary examination conducted by the Office of the Prosecutor, they were begun prior to the withdrawal of the Philippines. And so the provision that was or the wording of the provision that was used by the majority in that decision was that the matter was already under consideration of the International Criminal Court prior to the withdrawal of the Philippines. And so it shall not prejudice the continuation of those matters which are already under the consideration of the International Criminal Court. So the contentious issue here is that how do we interpret or what do we mean by the court? When you say International Criminal Court, it doesn't consist only of a court. Even the Office of the Prosecutor is considered to be an organ of the court. So when you say International Criminal Court, that also involves or proceedings before the International Criminal Court. That may also be interpreted as including proceedings before the Office of the Prosecutor. So I think that's the key that's the key issue here, whether the proceedings, whether the preliminary examination conducted by the Office of the Prosecutor would qualify as you would qualify the proceeding as a matter under the consideration of the court. So if it qualifies as as part of the matters under the consideration of the court, then it shall not prejudice the continuation of the exercise of jurisdiction of the International Criminal Court.
All right. Now to go, how would you describe the arrest and the trial of former President Rodrigo Duterte for the ICC, for the Philippines, and for the world?
Well, I think this is a lesson, at least for us in the academe and the legal community. You know, this is a very curious matter, and we've been following this up because definitely this will enrich the study of international law, and it has opened the eyes of many Filipino students, many Filipino lawyers about the possibility for international practice, that they should not only confine their views within the domestic application of our laws. And of course, we have also seen here that international law can actually complement domestic law, particularly when we are, for example, we have the IHL law in the Philippines. We have Republic Act 9851. We actually have the jurisdiction. We have the law. We have the appropriate law to prosecute this, to raise and prosecute and even to punish these crimes if ever there is, if culpability is determined. However, we never took that opportunity because practically until now, no criminal cases have been filed involving, no serious criminal cases have been filed involving these things. And so we now see international law in action. We now see the Rome Statute complementing national jurisdiction. So it's giving us the it's giving us the idea that when that we have the international community, which is very active in ensuring impunity, and that
okay.
it will complement national jurisdiction when the need arises.
I want to thank you so much for joining me today, Dean Ralph Sarmiento. I hope to see you again soon.
Thank you very much.